Final matter to come before the court this morning is State of Ohio versus Antonina, Pevnev. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve any time and you let me know when you get started, I'm keeping the clock this morning and can keep you apprised of the passage of time. The court's read the briefs and we are ready to proceed when you are.
Thank you, Your Honors. May it please the Court, Attorney Matthew Kishman on behalf of the appellant Antonina Pevnev, and I'd like to reserve 3 minutes for rebuttal. This action is before the Court this morning following my client's convictions at jury trial of 1 count of robbery, 1 count of tampering with evidence, 1 count of failure to comply, 1 count of obstruction, and a misdemeanor count of theft. Today we request this Court reverse her convictions because the jury's verdicts were against the manifest weight of the evidence. As the Court's aware, the standard of review for addressing manifest weight of the evidence assignments of error was outlined by the Ohio Supreme Court in State v. Wilson, where the Court instructed appellate courts to assist as the 13th juror and review the entire transcript on appeal in order to resolve any disputes between conflicting testimony. The standard of review was clarified in State v. Pevnev, where the Supreme Court outlined several factors that I think apply heavily in my client's favor in this case, including whether the evidence was contradicted, whether witnesses were impeached, what was proven, the certainty of the evidence, the reliability of the evidence, whether the evidence was self-serving, and whether the evidence was vague, uncertain, conflicting, or contradictory. For the sake of my argument, I'd like to outline how these factors apply in turn for each of my client's convictions. I'd like to start with the theft conviction because, of course, that underlies the robbery conviction as well. The state's theory in this case, Your Honors, was that my client took between 20 and 25 items of clothing. She went into the fitting room at Kohl's and Avon. She concealed these items of clothing into her purse and then left this store without paying. However, I think in reviewing the record, the court will find that there was no direct evidence that a theft was committed. In this case, only circumstantial evidence. No one witnessed my client place any clothing into her purse. The testimony merely reflected that she took clothing into the fitting room. The witness thought that her purse appeared bigger as she left, and that she left without paying. However, evidence...
Was there testimony, counsel, that from the loss prevention officer that she instructed the clerk to go into the fitting room and to check and make sure there was nothing in there before and nothing afterward?
There was, Your Honor, but I don't believe that's conclusive as to the issue as to whether or not all the items must have been on my client's person, because there was also testimony that my client placed several items on hold as she left, and there was testimony that there were still items in her cart as she left too. So that doesn't mean, as a matter of fact, that just because there were no items still in the fitting room that they must have been on her. Moreover, in addressing, where did this clothing come from that was eventually retrieved from my client's car and by the side of the road, the loss prevention officer testified that the list, which I believe is State's Exhibit 5 that she prepared of all the items that were taken, was made after the fact, and it was comprised solely of items that she recovered at the scene, which is highly problematic from my client's perspective because, it presumes that anything that was recovered must have been stolen that day.
Wasn't some of that stuff caught in the video of her putting it into the cart?
There was testimony that some of those items were placed into the cart, but there was also testimony that my client frequently purchased multiple items of different sizes from different Kohl's for her daughter, who was physically unable due to medical conditions to go shopping. And we saw that there was a receipt later introduced on cross-exam to the loss prevention officer that, my client did in fact purchase some of those items the day before from Kohl's. So we know that that list was not an accurate representation of what she took that day, if anything.
You made reference to your client's daughter who was physically unable to go shopping.
Well,
is this the same daughter that your client indicated she sent to go shopping for her?
It is, Your Honor, and I guess I misspoke a little bit. physically unable is probably a bad way to word it. She testified that she had a hard time getting around and that her mother frequently purchased clothes for her to try on, so she could later return some of the sizes that would not fit her. But obviously by appearing in court, we could see that if she pushed herself, she could actually have gone to Kohl's in theory.
And the daughter testified at trial.
That's correct. And lastly, for the theft conviction, Your Honors, I'd like to just remind the court that my client testified, so all of the state's evidence was contradicted. She took the stand on her own behalf and said under oath, it's coming from a woman who's never been convicted of a crime, that she did not take any of those items that day. Which leads directly into the robbery conviction, and I think that that conviction must fail as well under manifest weight analysis, not only because I think the theft conviction, which is an essential element of the offense, would fail, but also because I don't think that the state proved the physical harm element either. I think that there's substantial credible evidence for this court to rely on that any force, if any took place, was minimal force as outlined by the court in State v. Eskridge. The loss prevention officer's initial call to the police said that my client pushed her out of the way when she was going to her car, and it wasn't testified to that my client struck her in any way until I believe it was brought up for the first time on cross-exam by the trial counsel for Ms. Pevnev. And I'd like to point out the fact that Ms. Ahmad, the loss prevention officer, testified that she did not she did not leave her post in the security office to confront my client until she saw that she had already exited the store.
What's the relevance of that?
Well, it's relevant because my client didn't have a cart with her. She's not unloading any merchandise that she just purchased. She's going directly to her car and leaving. Whereas this woman has to leave her post in the back of the store and intercept her before she can get to her car, which would lead to the natural inference, well, how does she get there before my client does? And moreover, if my client did just commit a theft offense, why would she take her time and waste it assaulting this woman after the fact? I think that the reasonable inference, if any, is that if she was confronted by the loss prevention officer, she merely would have pushed her out of her way so she could leave. But I think that's also contradicted by the fact that Ms. Ahmad testifies that my client waits at the stoplight with her turn signal on, which one would assume someone who just committed a theft offense, who struck a loss prevention officer, who's now fleeing from the scene, is not going to be waiting at a stoplight for it to change colors.
Well, the police officer testified to that, correct?
I don't believe so, Your Honor. I believe that they first saw her after the fact, as she was several roads away.
And she didn't return in front of the
Correct.
police officer.
Correct. Next, I'd like to address the tampering with evidence conviction, which I believe fails because I think that the mens rea, quite frankly, is lacking. Obviously, tampering with evidence requires as an essential element that my client had the purpose to impair the clothing's availability as evidence in a proceeding or investigation. The testimony from the officer who was following her was that she threw it out the window of her car. This happened at about 5:30 in September. You can assume the sun is out. This doesn't conceal the evidence. If anything, it brings it to everyone's attention. And lastly, I'll address the convictions for...
How did she expect the robbers to get those clothes out of the road?
I don't think that she expected them to get them out of the road. I think that she expected them to notice that she had lived up to her end of the bargain.
Because they would have recognized her vehicle?
Yes. Finally, the failure to comply and obstructing official business convictions. Again, I think that the mens rea is lacking here. The evidence that my client was intending to flee the scene, fail to comply, hinder the police in their duties is contradicted by my client's own testimony that she was happy to see the police arrive that day, that she felt that they were kind of her safe harbor after the end of this whole series of events, and also that she was not aware that the police were trying to pull her over until she was stopped.
Was she not aware that she did a U-turn right in front of the police car?
I'm sure she was aware that she performed a U-turn, but I don't believe she was aware that the police vehicle was there and observed it.
So basically, it seems like the entire appeal rests on your client's credibility.
I would say that's fair, Your Honor.
Okay. And of course, our precedent, as well as that of the Ohio Supreme Court, is that the trier of fact really is the one to determine credibility, because they get to see witnesses and their demeanor. We typically don't override those considerations.
I think that the standard could also be summarized as when the court finds that the jury has lost its way in coming to its verdict, the appellate court is able to review the entire record and see if the convictions were against the manifest way of the evidence, which I do think applies here. That's all I have. Thank you.
Good morning, Your Honors. On behalf of Appellee, the State of Ohio, Mary Solanska. This case and the arguments that have been presented in the brief and before you today does come down to the defendant's credibility. And in reading this transcript, I think that it becomes clear that the defendant told an absolutely fantastic tale of events, including a robbery in Canada, because that was an attempt to explain why she didn't call the police after the first time she was carjacked. She says that she was carjacked essentially twice in the road, and then a few days later these people came to her house and attempted to steal money from her. She said, oh, I don't have any money, but you know, if you want, I can get more clothes from Kohl's. I think they even asked her, according to her testimony, asked her if she could. So the plan was she was going to go to Kohl's, not the Kohl's in Avon, but a different Kohl's, get clothes, and then she was going to meet them and turn over the clothes to these two alleged suspects or persons that had carjacked her. She says her daughter went to Kohl's and bought something like 3 or 4 items, and it was a different Kohl's, I think it was in Rocky River, and that those were the items that she was going to turn over to these people. I would submit, as to one of the last remarks counsel made, the mens rea for the tampering, the purpose to impair the items of clothes that she threw out of her car, is contradicted by her testimony that she only had her daughter buy like 3 to 4 items, because what were recovered in the roadway with Kohl's tags on many of the clothes and in a condition that was would show that they hadn't been there very long was between 19 and 20 items. I didn't have an exact count. The loss prevention officer testified it was 19 or 20 at trial. That's the mens rea. The court, there does not have to be direct evidence. The court can rely on circumstantial evidence, and that's one of the first things counsel mentioned, that this case was largely circumstantial. I would dispute that. The state disputes that it was circumstantial, because there are portions of this that are caught on videotape. You have a security guard who says, there are cameras in Kohl's, I can zoom in to the point that I could read the tag on the clothing that the person is looking at or putting in their card or holding up or whatever. She does that in this case, and the loss prevention officer makes a list of items that this defendant was putting into her cart. It's not a comprehensive list, because she picked up some items that were on hold from the service desk, and she had been in the store before the loss prevention officer started tracking her movements with the camera. But the suggestion that she was simply double selecting, which is, the security guard said that's common for people to pick up 2 of the same items so that they can conceal one and put one back on the rack or whatever. she then tries to explain, hey, I normally buy multiple sizes of items for my daughter so that then I can return whatever she doesn't want or doesn't fit. This is a young lady, I'm not sure of the exact age, but she's at least of driving age, and the clothes that we're talking about were taken from the girls' department and are smaller size clothes consistent with a very young child. So these would not have been items that she was taking for her daughter. And the jury was free to consider that in weighing the credibility of Ms. Pevnev's testimony. The jury doesn't have to accept the incredible as true, and nor does this court. And I would submit that this story that Ms. Pevnev told was completely incredible. She, as I said, she went on about a robbery in Canada. She gave a significant amount of details that she had jumped out of the car and that she had jumped in front of the car to stop them and to get their license plate number. And because she had a license plate number in that case, and the police were eventually able to catch the robbers, that would explain why when she's saying someone robbed her, carjacked her along the side of the road, she didn't go to the police. But you have to remember, not only did she not go to the police, she didn't even tell her husband. And that's her testimony. She says, I didn't tell my husband that I got robbed. Well, I'm sorry, if my first phone call is not to the police, you know that the second one is going to be to your spouse to say, can you believe this just happened to me? So I think that the jury was free to look at that and weigh that against their everyday understanding of life and, to kind of judge that as far as the defendant's credibility. She says that not only did this happen once, but it happened twice in one day. First she gets stopped and she inadvertently tells this gentleman where she lives, and then they come back and there's a lady that gets out and robs her at knife point and takes money from her purse. She doesn't report either of those incidents. And then later she says she tells her daughter convinces her to report it. She first goes to Rocky River and they tell her no, it was in Lakewood. She then says she goes to Lakewood and they say no, it was in Rocky River, and she says, well then never mind, and goes home. But there's nothing to support the defendant's testimony that she did any of those things other than her own daughters. And I would submit that the testimony is very self-serving. I think throughout the trial, or throughout the defendant's testimony, she makes many, many self-serving statements. She then makes this agreement to steal clothes from Kohl's, but she has her daughter go and buy them instead of stealing them. But the amount of clothes doesn't match up with what the daughter bought. And we have the security guard who says, I was able to look at the list of items, and here's how this plays out. She writes down items that she sees the defendant take and put into her cart. They check the fitting room before and after the defendant goes in, and there's nothing in the fitting room. They check the cart after the defendant has gone out of the store without paying anything, and she quickly compares it to the list and does a rundown of the items that are in the cart because there are some clothes there. And she finds that there are several items, or she doesn't mention how many, but there are items on her list that are not in that cart. They were not in the fitting room, and her testimony was that she described the defendant's movements throughout the store. After she leaves the fitting room, she doesn't go back to the departments where there'd be an argument that maybe she put something back, although the video probably would have belied that. The officer says she goes to the front, she stops and puts items on hold at service, which they compared also, and she goes out the door without paying for anything. And then we have these unaccounted for items. I would submit that the jury was then at that point free to infer from all of that evidence that there were in fact items that Ms. Pevnev stole.
Now, were any of the items that were retrieved from the street items that were on the list that the loss prevention officer was making?
Yes, there were at least 2 items. I believe it was an orange pair of pants and a purple shirt. Those 2 were specifically described as being items that were found in the Burger King parking lot and were on the list of items that were not accounted for that the defendant had put into her cart. The loss prevention officer, well, let me back up. When the defendant was eventually stopped, and this is after she does a U-turn across 3 lanes of traffic when she sees a police officer, and I think the jury was free to infer that that was the reason that she did that U-turn and went across the lanes of traffic. She's going down the road. The officer is behind her. Now, she says she didn't know the officer or that the police were trying to stop her. what would be the logical conclusion in your mind if you've just committed a pretty big flagrant traffic offense of doing a U-turn on a busy road across 3 lanes of traffic, you saw a police officer, and then you hear lights and sirens, and the jury was free to infer that, yes, she did know they were after her. And it's at that point, and this supports that conclusion further, she starts throwing these clothing items out of the car, and the officer clearly sees it. There's the dash cam. She's throwing clothes out of the car. Bless you. And then when she gets in the Burger King parking lot, again, does she know the police officers are after her? They turn into the parking lot, lights and sirens still on, and they circle the store following her twice. And they're going at what the officer described as a fairly high rate of speed for those conditions to be in a small parking lot, to circle that building twice at 30 or 35 miles an hour. I would submit that the evidence does support the jury's decision to convict her on knowing that she was fleeing and eluding the police. I think there's substantial and overwhelming evidence. It's not a term I normally bandy about, but in this case, I think the evidence as to each offense was very overwhelming. And the defendant's testimony, rather than explaining all of these things, although she attempted to explain it, simply highlights the fact that she's not credible. I think that for many reasons, this is just an extremely incredulous story that the defendant tells of the robbery and everything. Also of note, when I was reading over my brief today, I picked up on something that I mentioned in the facts, and I didn't necessarily argue, that I thought was interesting. The defendant doesn't make a formal statement to the police when she's taken back to the police station. And when the officer tells her that she's under arrest for robbery, her immediate answer is, "I didn't punch that security guard." Well, there's no testimony or evidence to show that the officer had ever said, we want to arrest you because you got in a confrontation. He didn't explain it to her. He said, "You're under arrest for robbery." And that's what the officer testified to. So I would submit that that shows a consciousness of guilt in this case, because she's basically admitted a fact that's consistent with what the loss prevention officer testified to, and hasn't been mentioned by anybody else at that point. If she truly didn't have any reason to believe, and she denied that there was ever a confrontation, that she denied that she took anything from Coles, and she denied that there was ever a confrontation with the loss prevention officer. So then for her to say, when the police tell her she's being arrested for robbery, "I didn't punch that officer," that's another point. I think that the evidence, I think the record supports in this case that the jury made the right decision in this case. There was a great deal of circumstantial evidence as well as direct evidence of the missing clothes that the officer confirmed were found in the Burger King parking lot. I think when you look at all of that, this is not a case that we can say that the jury lost its way and created a manifest miscarriage of justice. This case does not require reversal. As to the force of the robbery, there was one other thing I wanted to point out about that. We have this argument today that it's sort of like it was only a minimal amount of force if you believe the security officer's testimony. But what the robbery statute says, and I can't quote it directly, but what the robbery statute says is that in committing a theft offense or fleeing immediately thereafter, you cause or attempt to cause physical harm. So the state didn't have to prove that the officer was injured or that there was some kind of physical harm. Not even that. We had to prove that she attempted to cause physical harm. The officer said, "She balled up her fist and punched me in the ribs." That's a punch that's designed to knock the wind out of somebody. And that certainly would slow someone down from chasing or following you. And the officer also says, "She then shoved me to run to her car and leave." The fact that she may have stopped for a traffic light on Detroit, the officer wasn't in a car. She doesn't jump in a car and chase this defendant. So why would the defendant think that she has any reason to run a red light or flee in some way at that point? It's not until she turns onto Detroit Road and she goes to make the turn on the connecting road to get on Route 2 or I-90, and she sees the police officer, that then she says, in her mind, you can imagine, uh-oh. She does this U-turn across 3 lanes of traffic, and she goes back out onto Detroit Road, and she goes on down to the Burger King, which is just a fairly short distance. There's like one intervening light and a couple of businesses. And she pulls into that business, And she circles around it twice, throwing clothes out.
Well, let me ask you this regarding
Yes.
the physical harm. Let's assume that we focus in on let's assume that there's some doubt regarding whether she balled up her fist and hit the loss prevention officer. Is the shove enough? Does that constitute physical harm?
Yes, yes, that's been my experience, and the case law supports that the act of simply shoving somebody during the commission of a robbery so that you can flee, or when you're fleeing after, is sufficient to cause physical harm, because you don't know what's going to happen when you shove that person. If you shove them, you may be attempting to shove them hard enough to cause them to fall into a rack, something else in which they could be injured. So I think that the state has met its burden, and the jury rightfully believed that there was there was physical harm or an attempt. In this case, I would argue the evidence would support that it was an attempt to cause physical harm, because the security officer didn't testify that she was injured in any way. She testified to the events that occurred, which were clearly an attempt to cause physical harm to the officer. The act of merely shoving somebody, when you use physical force, that's an attempt to cause physical harm. When you're using that force against a person, I think that the evidence in this case is overwhelming, and the defendant's story is dubious at best. I believe the evidence supports that it's incredible, and the jury chose not to believe it. And that, under the manifest weight, is something that this court has to give great weight to in determining whether to affirm or overrule this defendant's conviction or reverse this defendant's conviction. The state would ask that the court overrule the defendant's single assignment of error and affirm her conviction and sentence. Thank you.
There's just a couple of remaining issues I'd like to address. First of all, the state's argument that these clothes were of smaller size, so therefore they could not have been for her daughter, I think is contradicted by the fact that my client's daughter testified saying that due to these medical conditions she had extreme weight fluctuations. So I think that it's reasonable to believe that she could have fit into these clothes. And there was a question from the court as to whether or not the items placed in hold were ever double-checked. I think in reviewing the record, the court's going to find there was never testimony from Ms. Ahmad or anyone else from the Coles Loss Prevention Office that prior to calling dispatch or attempting to intercept my client from going to her vehicle, that Ms. Ahmad or any loss prevention officer verified with the customer service or whoever would be working at the hold desk that none of those items were placed on hold. And also, this list of items that keeps being referenced by the state and focused in on the brief, Exhibit 5, again, I just want to highlight the fact that this is not the list that Ms. Ahmad created as she saw my client going through the Coles. This is a list that she created after the fact. After she goes to the scene where all the clothes are, she recovers clothes from the street, she recovers clothes from my client's car. That's what's on this list. The list that Ms. Ahmad testified to that she created as she was watching my client go through the Coles and put items in her basket, that was never introduced at trial. Ms. Ahmad testified that she had lost it or destroyed it or whatever, but we never saw evidence of that list. And lastly, going back to the physical harm element of the robbery conviction, I believe that the court's got two options. They can either believe what Ms. Ahmad testified to, in which case, first I strongly caution the court against doing that. I think that Ms. Ahmad revealed herself not to be a reliable witness based largely off the fact that she testifies extensively about the September 11th. That's why she had her eyes keyed in on my client when she walked into the store the next day. On direct, she goes over September 11th numerous times. Conveniently, she never references the fact that September 11th, my client bought all of those clothes and she's got a receipt from that day. But she leads the jury to believe that she's testifying that these items may have been stolen, we were suspicious, we thought a theft occurred that day, but never brings up the fact that she actually went to check out and she bought these items. And those items are still in her car. So for that reason, I caution the court against relying on Ms. Ahmed's testimony for the physical harm element. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website. Thank you. We are adjourned until Tuesday.